ಮೇಡಮ್ ಯೂಟ್ಯೂಬ್ ಲಿಂಕ್ ಶೇರ್ ಮಾಡಿದೀನಿ ನೋಡಿ. ನವೀನ್ ನೋಡಿ, ಯೂಟ್ಯೂಬ್ ಲಿಂಕ್ ಶೇರ್ ಮಾಡಿದೀನಿ ಚಾಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ.
ಹಾ ಸರ್, ನೋಡ್ತೇನೆ ಸರ್.
ನಿಮ್ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಡಿ ಅದನ್ನ.
Good evening, one and all. I, Rula Irshad, on behalf of the JSS Law College Moot Court Committee, humbly welcome you all to the online training session as a part of the preparation for the intra-collegiate Moot Court competition. Throughout the length of this training session, the Moot Court coordinators and core committee members will be dealing with important aspects of Moot Court, such as research, memorial drafting, court etiquette, and court procedure. The members will also be doing a demo moot towards the end in order to give the newcomers an idea about how moot is done. We sincerely hope that both the juniors and seniors pay attention to the segments. Should there be any doubts, kindly send in your queries through the text in Zoom. And those who are watching the stream on YouTube, please send your questions on the official Moot Court Society WhatsApp group. They'll be answered later. Without further ado, let the training session begin. I would like to call upon core committee member Roshni Ponnamma to introduce the concept of research, and Moot Court coordinator Pavni Randeo who will further elaborate on the same.
Good evening, everyone. I am Roshni, final year BA LLB, core committee member of JSS Moot Court Club. Today, I, along with Pavni, student coordinator of JSS Moot Court Club, will be dealing with research. Research is a very important aspect of mooting. So every one of you will be wondering what to research and how to research. So first, let's see what is research. Research refers to a systematic search of particular topic or issue. So we can also define it as art of searching knowledge. So here we are concentrating mainly on legal research, that is identifying and retrieving information that is necessary for supporting the legal decision. So the main purpose or importance of research is that it will help us to draw conclusions and solution, and also with proper method. It will develop our thought process and also will give us creative ideas, and it will equip us to evaluate the research and make rational decision. Then in case of moot, research is the best way to learn, and also it will help us to learn the art of advocacy. So a proper research methodology will adopted for moot will give us good piece of work, and ultimately various practical skills will also be polished. Now, to see what exactly to research, that is, the research has to be constructive. Only what is required has to be researched. So before starting your research, there are few things that has to be noted. First thing is that for moot competition, you should know the facts and then the law. So to know the facts, you have to read the problem several times. After reading the problem several times, you can also explain it to someone, so you will know what points you have to focus on. So once you know the facts thoroughly, then you have to identify the relevant law. In that, you have two points. That is, one is jurisdiction, and second, how the party should approach the court. That is maintainability. If the issues or contentions are already framed, then need not worry. If it is not framed, then you have to frame the issues and also sub issues. Now, this is where your research begins. So steps of research is that first, as I mentioned, you will know the facts, then the legal issue. After that, second step is that you should know the sources where you can find where you can research. There are two sources. First being primary source, which is credible and reliable, like case law, statutes, etc. Then secondary source, where the work has already been done for you, like somebody would have researched and already cited important cases relating to that topic, such as legal articles and law journals. And the third step is that you should make sure that you use a good law. Now, first, the significance of statute. So as we know, statute is a written law that is passed by the legislature on a state or federal level. Here, based on the facts, once you know you have to find out the relevant law and make sure you go through the BEAR Act, because BEAR Act is only document that will give you a proper information or about the provision of the Act. And also make sure you go to the recently amended version of the BEAR Act. In several cases, even the secondary sources like law journals will also give you certain statutes. But after knowing the statute, make sure to go to the BEAR Act. Then one of the most important steps is that you use good law. Now, what is good law? Good law is a law which has not been struck down or not invalidated or not declared as unconstitutional. So do not cite statute that has been overruled, amended, or which has been unconstitutional. So always refer to the updated version. Once you know the statute, now you start finding case law. So the purpose of legal research is to find support for your argument. So once you state an argument, you have to back up with the case law. So there are two simple steps to find case laws. First being searching using the relevant law or provision or using keywords. Second being, you can also search cases based on the secondary sources. Like when you read an article, you find a case, then make sure you go through the case and like judgment thoroughly. Only when you go through the judgment thoroughly, then you can include or cite it in your memorial. Then important points to be noted during citing cases is first, you should know the ratio of the case. That is the main statement which will lead to the judgment. That is the principle behind the case law. Second, you should know also what is non-binding part of the case, and do not cite a case which has been overruled or which is pending for judgment. And also, when you cite a case, make sure you have the correct citations and correct authorities in the footnote. So coming to the secondary source, that as I said, if you don't like, if you're new or unfamiliar to the legal principle, like if it's the field is new to you, so it's better to start off with the secondary source, like articles or books or law journals. So here the work has already been done for you, and they've already cited few important cases that you can refer. After you learn, after you go through the law journal or article, make sure you write down the cases and go through the case judgment from the authorized website. Then use the sources which are credible and publication which are reliable. Like blog posts and news articles are not credible, so do not use it. And also make sure that research is not mainly based on these secondary source. They can just be used for your arguments. You have to make sure that you use primary source when you actually make a research. Now, after you go through all this, the next question you have is what to do with the research. So before putting the research into use, make sure you evaluate the research. That is, if you use secondary sources like law journal and all, make sure it is in the updated version, and it is not there is a recent development. Make sure to add it. Then, if it's legislation, like see to it that it's still in force. And if it's case law, see that it's not been overruled or they overruled, and make sure it's from the correct court. Like only Supreme Court cases can be cited, whereas High Court cases are persuasive, while the Supreme Court cases are binding. Now, once you evaluate the research, you should know what to do with the research. So once you know what you're going to argue and what are you going to back up for that arguments. So based on that, you will apply the law to the facts of the case. So important thing to note in the research work is that the research has to be constructive, because law as a subject is very vast. So you should research on what only is required, because and you should know when to stop, and you have to evaluate your research and then apply it. And law keeps changing, so update your research. Statutes evolves and courts are constantly issuing new opinions. So make sure you're updated and read the case laws, like read the judgments carefully and then cite it. Thank you.
Thank you, Roshni. Good evening, all. I'll be continuing with the research sources and citations, how to go about it. So it is important that we know various databases from where you can do your research, and you can have your comprehensive knowledge, and they're reliable sources. So first is Manupatra. As you all know, that our college also has the Manupatra access, and the college ID and password also you guys can take down. The college ID is JSS Law C Temp, and password is JSS at 2021. The second source is sorry, one second. Second source is S2C Online. So S2C Online is a product of Eastern Book Company, where you'll find all the Supreme Court cases, and they usually do the weekly updation of all the Supreme Court judgments as well. The third one is Jester. So Jester is used for all your articles and your main, you'll find all the important articles that have been published. And similarly, Westlaw Asia is also there. It's not moving through. I'm so sorry. There's something happening. And sources which cannot be cited are especially Indian Qanun. You can refer Indian Qanun, but you cannot cite them in your memorials. Case Mine also is one of the websites you cannot cite. Then there is Bar and Bench and Live Law. You cannot cite judgments from Bar and Bench and Live Law. Alternative sources that you can use is Juris.net or Supreme Court's website, where you will find various case laws. Next is how to cite various sources and how to go about it. The first thing comes is signs and signals. In signs and signals, you have two main words, that is ibid and supra. So ibid is used to refer an immediately preceding authority, either exactly as it has been cited and the number. So for example, like you have a footnote number 10. Let's say you have taken reference from Markham's law relating to arbitration and conciliation. You have taken that and you have taken a page number. Now you have to cite the same page again. So instead of writing the entire citation in your next footnote, you just write 11 ibid. So that's how you cite. The next one is supra. It's when an authority has been fully cited previously by an author, and supra is used as the same authority at a later point. For example, you're taking up paragraphs from V.N. Shukla and you're citing it. So once you have cited and again you have to cite the same thing, you'll just write supra, and you'll write the supra and refer the paragraph number. The second point here is the abbreviations and details, how you have to provide the abbreviating names and details. And you have three categories. First is date. So dates always go by month, date, and the year. Or it can be as well as cite. If you're numerically citing it, it has to be day, month, and a year. Abbreviating names. Now, you cannot go on writing full long names. So, for example, it's Mahendra Pal Singh. So you can go about write M.C. Singh. And for the URL, you can also provide. You have to provide the link, and then you have to say where it is available at, and then when was the last seen on, when was your last research done on that website. Now, the important part is how to cite a case. A case citation for a published judgment includes the full name of the case, and the citation has to be reported in which it's published, and the first page of the case has to be given. So first you have to give the first page of the case. It's with regard to your compendium, when you have to present the compendium part. And in order to publish the So a case can be reported and as well as the unreported, and can be published and unpublished. So when you are publishing, when you're citing a published case, it goes, for example, Keshananda Bharati versus State of Kerala, AIR, that is All India Reporter, 1973, and then Supreme Court is stands for SP, page number 1461. Whereas, how do you cite an unpublished decision? It's name of the party, appeal number, and the court that it belongs to. So, for example, Mohammed Amir Kasab versus State of Maharashtra, criminal appeal, the number of the case, and which year it belongs, then the entire whether it's a transfer petition, criminal number, again, when the transfer petition was being done. Further, statutes. So in order to cite a primary legislation, first mention the section or the order or the rule number, and then the name of the statute and in which year it was being passed. To indicate a section, you have to capitalize it with the letter S. The letter S should be capitalized. And to indicate multiple sections, you can use double S, but the first S has to be capitalized. So for example, if it's section 376, clause 2, clause G of the Indian Penal Code 1960, it has to be cited like that, with S being capital, and then you can go. Further, moving to the bill, in order to cite a bill, first mention the name of the bill, then the year it was being drawn, and what is the current status of the bill, if it has been available in parentheses. If it's unavailable, you have to say what's the status with regard to, and you have to state the author's name. So how do we cite a bill? You have to first mention the name of a bill, then the year and statute, and then the status of the bill. So for example, the competition bill that is pending the amendment. So the competition amendment bill 2012, and then bracket you have to write pending. But if a bill that has been already passed, that is the prevention of money laundering amendment bill 2011, passed by which authority, like Lok Sabha on this date. Now the most important is how to cite the Indian Constitution. In order to cite any article, schedule of the Constitution, first mention the criterion, that is the number, and then you have to say the Constitution of India. It's example, you have to use short form or abbreviated form of article can be as ART dot. So ART 14, comma, the Constitution of India, Schedule 9, the Constitution of India. That is the correct citation of the Constitution of any article. Further, you can go with parliamentary committee reports. Parliamentary committee reports are cited by mentioning the name of the committee that passed it, either in the House of Rajya Sabha or House of or Lok Sabha, either of the houses. And you have to first state the name of the committee, House of the Parliament, and title of the report and the year. Then similarly, reports by many ministries are also cited in the same format. Then parliamentary debate. Now, it's very important that if you're taking something as an opinion or as a thing being said by any minister or the prime minister, it should be a parliamentary. It should be a parliamentary statement rather than a statement issued in the press, because those are their general opinions, which cannot be a reliable source. So parliamentary debates can be cited in an example like statement by Prime Minister, statement regarding Civil Nuclear Energy Corporation with this theme, and it was dated on 27th February 2006. Lastly, Law Commission reports are very important, and it is important if you're taking anything from the Law Commission reports, especially their recommendations, and you're using them. So you have to cite it by mentioning which the report number, that is 181st Law Commission of India report. Then what is the amendment saying, or what is the conclusion? Let's say they have amended section 106 of Transfer of Property. So amendment to section 106 of the Transfer of Property Act, available at where this amendment is available. You have to post that with the PDF, and when was it was last seen by you. you have to refer that in the research.
Use tab for next slide. Press tab in the keyboard.
I'm doing that, so it's not happening. I don't know.
Please stand by. There is a technical problem.
Pavni, you please close your slides. I'll try to screen share from here.
I
if it's
am
possible.
actually not able to close the slides. Can you stop sharing my slides?
Use shift plus tab for next. Shift, then press tab.
Naveen, remove me from the meeting and I'll join it and you guys continue. I don't know what's wrong.
Yes, 1 second, 1 second. We are so sorry. There is a technical glitch. We'll be back. You people stay put. The presentation will be back in a minute.
Can you see it, Naveen?
Yes, we can see it. Circulars and notifications. Yes. You don't do it. You don't enlarge it. Don't go for a full screen. You just do it like that only. No problem.
Sure. The next part of the research is circulars and notifications. So official government notification, that is the Gazette notifications, are reliable sources and you can cite them. Just make sure that those notifications have not been overruled or have not been surpassed by the government or have not been cancelled. Second is circulars issued by any ministry, especially health ministry or the central ministry or any of the main union ministries. You have to ensure again they are not being overruled, and only government authorized notification can be looked into and can be cited. And my last point being inadmissible content in the memorial or during your Moot for your research is known fact. You cannot just, if there is an established fact, you cannot quote that fact. And newspaper reports which are not being proved, you cannot take them as your census or as your area of research. And as I said earlier, also opinions or speeches of political leaders or bureaucrats cannot be taken in. Thank you.
Thank you, Roshan and Pavni. We apologize once again for the technical issues. Thank you for being so patient. I now call upon core committee member Saloni Oliveira and student coordinator Prajwala Satyaprakash to introduce what a memorial is and explain how to draft one in the ideal manner.
Am I audible?
Yes.
Okay. Good morning, good evening, everyone. So I am Sidoni Oliveira from final year BA LLB and a core committee member of JSSLC Moot Club. I and Prajwala, the student coordinator, will be giving you an insight as to what a memorial is, and I'll be dealing with the introductory part of the memorial, and Prajwala will be telling you on the body of the memorial along with what a compendium is. So let's begin with a simple question. What is a memorial? So a memorial is basically a written submission which is a product of your research on the given proposition. So basically the contents that you research on the proposition given, you write it, you turn it into a written submission, and that is a memorial. The memorial is as important as your oral arguments itself, and it contains equal weightage as that of oral arguments. So a memorial basically has all the facts and the arguments that you will be presenting, along with the authorities that you will be relying on, and the prayer or a relief that you seek from the court that you will be presenting your petition in front of. So every proposition has the memorials on both the sides. So when a proposition is given to you, you have to prepare your memorials on both the sides. So there'll be a special color coding that is given to the parties that you identify. So there's a usual standard coding that is unless otherwise decided by the organizers. The usual standard color coding is it will be blue for the plaintiff, petitioner, appellant, complainant, applicant, or a decree holder, and it will be red for the defendant, respondent, accused, opposite party, and the judgment debtor. So this is the standard color coding that is used, of course, unless it is decided by your organizers. And depending on the kind of proposition, you have to recognize the designation of your parties, and you have to mention it in your memorials accordingly. Also, there are basic do's and don'ts that you must take regard to. You must, when you frame your memorials, you have to present it before the proper court. That is when you read the proposition, go through it carefully, maybe 3 or 4 times, and then decide before which authority you will be presenting your petition before. So next you have to recognize the proper jurisdiction of the court. That is, you have to recognize the proper provision of the law which gives the particular court the jurisdiction to decide your case. So this is also another important aspect that you have to take regard to. And do not mention wrong designation for your parties. For example, if your party is a complainant and you make him the plaintiff, it is entirely wrong. So you have to take regard to the designation of your parties very carefully. Then keep your research very relevant. Do not go ahead of the facts that are needed. For example, if your proposition says that Karnataka is a state in India, it is not a relevant fact. You don't have to research on it to show that Karnataka is actually a state in India. So it is immaterial as to your proposition, but it will be given in the proposition for your better understanding. Then when you're mentioning case laws, please mention relevant case laws only and make sure it is not overruled. Otherwise, it can be used against you in the court. Also, when you're going for citations, make sure you have the recent citation method, that is Blue Book citation 21st edition for all your citations. And also the relief or the prayer that you seek from the court should be very specific and very relevant, because that is what your end product of your entire arguments is. Therefore, your prayer forms an important part of your memorial. There are various basic do's and don'ts relating to technicalities. That is, first is when if you have read the rules that was already given by the college relating to the proposition that we released, it clearly states that you have to limit your font size to a 12 in Times New Roman, of course. So just because your arguments advanced are 15 pages and you have the page limit up to 25 pages, it does not mean you increase your font size to go up to 25 pages. If your arguments are 15 pages, that is well and good, just leave it there. Do not increase the font size in whatsoever cases. Also, do not keep your margin more than 1 inch. It is clearly given in the proposition that your margins have to be 1 inch itself. So make sure your margins are 1 inch in all the sides. And also when you are sending the hard copy of your memorials, make sure it is paper bound. That is, you do not use any plastics in it, or do not spiral bind it. Make sure it is staple bound and with a staple bound with a tape. And there is the numbering. The page numbering is very important. I will also be sharing the memorial with you so you have a better understanding. That is from your the contents of the memorial, from your cover sheet till your summary of arguments. It has to be in Roman numericals, and the page numbering from your arguments advanced till your prayer, it has to be in Arabic. Let me just share the memorial. Is it visible?
Yes, yes.
Okay. So moving on, this is how your memorial should look like. The cover sheet of your memorial should look like. So this is a memorial on behalf of the petitioner, and that is why it is blue in color. The cover sheet is blue in color. So the title sheet will always begin with the name of the competition that you are taking part in the header. This header is common to all your pages, and it has to be in bold, size 12 times New Roman. So whatever, whichever parts that you're making bold, it has to be in the same font, that is Times New Roman. And then comes your team code. So this is the only place where you reveal your team's identity, not your individual identity. Make sure this is the only place where you mention your team code. Not even in the contents of the memorial should you disclose anything related to your identity. So we will be shortly allotting you the team code, and this is where you have to mention it. And you have to recognize the proper court before which you are presenting your petition. So in this example that we have taken, it is the Supreme Court of India. So here you have to identify the proper court, and you have to mention it here. Next, you have to mention which jurisdiction or which case type, what is the case type of your petition. So here it is a writ petition, and therefore it is the original writ jurisdiction. And next you have to mention the case number. So depending on the type of case, the case number can vary. If it is a criminal complaint, then it will be CC number. Here it is the writ petition, and therefore it is the writ petition number. And then you have to identify under which provision of the law you are invoking the jurisdiction of the court. So here it is Article 32 of the Constitution of India. Therefore, this is the jurisdiction that provides this particular court the jurisdiction to try the case. Next comes your parties. Here, since this is a writ petition, it is the petitioner and the respondent. But depending on your case, you have to identify what is the designation that your party holds. For example, if it is a petition that you are presenting before a district forum, then it will be the applicant and the opposite party. So accordingly, the designation will change. Then comes so written submission on behalf of whom. So again, you have to recognize the designation and mention it here. Then most respectfully submitted in the Honorable Supreme Court of India. And on the left side corner, you will mention the counsel for the petitioner and his signature. You don't have to sign it. You can just mention SB and the petitioner and SB. And this is the footer part, which is also common to all the pages. So here again, you have to mention submissions on behalf of which party. Here it is the petitioner. So on the cover sheet, you need not put the page number, because it is implied that it is page number 1. But from this next page, it can be continued, that is page number 2. Next comes table of contents. So here you have to take regard that it has to be in tabular form. that is serial number, particulars, and page number. So, like I said, from your list of abbreviations to your summary of arguments, it shall be in Roman numericals. The page number shall be in Roman numericals. And from your arguments advanced till the prayer, your page number shall be in Arabic format. So, like I said, this is the footer part, and here should be your page number. This is the list of abbreviations. This has to be mentioned in alphabetical order. So list of abbreviations is the abbreviations that you use in your arguments advanced. Suppose if you have used the Allahabad High Court in your footnotes, so that will be ALL. So you have to mention it here, and you have to provide the abbreviated form of that. So it will be for the better understanding of the of any person who reads your memorials. And you have to mention only those abbreviations that you use in your memorials. You need not add any other abbreviations other than the one you have used in your arguments advanced. Next comes index of authorities. So like Pavni and Roshni already explained it to you, authorities are nothing but any books or rules, statutes for that matter, that you'll be relying on to prove your case. So here, the first we'll discuss how you write books referred. So books referred, again you have to mention it in alphabetical order, and it has to be in bold letters. So this is the general mode of citation that you write for a book. That is, first you have to mention the name of the author, then the name of the book, then the name of the publisher, and then comes volume. So this volume depends if the book has a volume or does not. And here, in the end, you have to mention the year of publication. Next comes dictionaries and law lexicons. So dictionaries and law lexicons, again, you have to follow the same method of citation that you use for the books. And if only you use any dictionaries and law lexicons for your research, only then you have to mention it here. Otherwise, it is not needed, and it is also not relevant. Next comes statutes and rules referred. So here, this is the part where you will mention all the acts or rules that you refer for your arguments advanced. And for example, in this instant case, that is here in this proposition, they have referred to Constitution of India and Karnataka State Legislative Assembly disqualification on the ground of defection rules 1986. So any statutes and rules for that matter that you refer has to be mentioned here. Next comes articles referred. So any articles that you refer should be mentioned here, and it has to be in alphabetical order and in bold. So first you have to mention the name of the author, then the name of the article, and then the name of the publisher of that article and when it was published. Next comes list of websites referred. So here Manupatra is a website that you can mention that which you refer to. However, you can't mention websites like www.google.com because it is not a website, it is a search engine. So make sure you mention only those websites that you actually refer for your arguments advanced. And again, it has to be in this particular format itself, that is http:// and www. The next part is table of cases. So table of cases, it has to be in tabular format and containing serial number, name of the case, and the citation. So Pami has already told you how the citations have to be mentioned. So here, while you are mentioning the table of cases, you are going to mention all the cases that you are relying on in your arguments advanced, and it has to be again in alphabetical order, and you have to mention proper citations for the case. So in this particular problem, there are 27 case laws that they have referred, but depending on your research and your arguments advanced, you can write how many ever case laws that you have referred. So this is the next very important aspect that that I was telling you earlier. This is statement of jurisdiction. So while invoking the jurisdiction of the court, you have to go through the provision of law that gives the jurisdiction of the court to try the matter. So if not, then your first issue of maintainability itself dismisses your application. So you have to take regard when you are mentioning the jurisdiction. So whether it is a writ petition, whether it is a special leave petition, whether you are producing it before any district court or matrimonial court. So you have to take regard to before which court you are presenting and which provision of law gives that court the jurisdiction to try your case. And then you have to mention the provision which gives the court jurisdiction. Then comes your statement of facts. So statement of facts, you might have noticed that your proposition may run up to 3, 4, 5, how many ever pages. But when you are writing it in your memorials, you have to make sure that that your entire proposition is made precise and written in a single page. So it has to be in a single page. So plain reading of your statement of facts should give the entire facts, and you shouldn't conceal any facts that are not in your favor but favors the opposite party. You have to be very transparent when you are mentioning statement of facts. It can be either in bulletins or it can also be in paragraphs, but make sure you mention all the material facts. Then comes your statement of issues. So statement of issues, in some competitions, they'll already give you few statements, few issues, but in some competitions, they might not give you issues. You have to frame your own issues. So here are this particular page, you have to mention all your issues, and you can also, even if they have provided certain issues and there is a provision where you can include certain other issues, then that also you can mention here. It has to be, while mentioning, you have to mention it in bold and it has to be in capital letters. So next comes summary of arguments. Summary of arguments is again your issues and the summary of the arguments that you are going to give in your arguments advanced. So in your arguments advanced, one issue might have arguments up to 4 or 5 pages, but when you are mentioning it in statement of arguments, in your summary of arguments, make sure it is just 4 or 5 lines. That is more than sufficient. It just has to give a gist of what basically your argument is. And when you are mentioning the issue, you have to make sure it is in bold and caps, and followed by your 3 or 4 lines of 3 or 4 lines of summary of your arguments. So this is where I conclude. And if you have any doubts up to this part, then you can drop it in the chat box or in the official group of Moot Court. So I'll be clearing your doubts. And now I hand over to Prajwala, who will be continuing with arguments advanced.
Thank you, Saloni. Good evening, everybody. This is Prajwala Satyaprakash, one of the Moot Court coordinators for this year. We look forward to your participation in the intercollegiate Moot this time. Now I will be dealing with the other parts of the memorial in continuation with what Saloni just explained. I'll be talking about arguments advanced, the prayer, citations and references in general, and the compendium. So arguments advanced. Arguments advanced is the first one. So arguments advanced, the part where all the oral submissions are. Okay, whatever you plead and pray for are all included in the arguments advanced. It elaborates all arguments using judgments and other sources as a reference. So generally 20 to 30 pages are provided for arguments advanced. So please try to stick to that. Like Saloni mentioned, the Moot proposition either has predetermined contentions or you're asked to frame them yourselves. So contentions or the issues that are framed have to be argued with both perspectives. That is, the petitioner, appellant, complainant, or the applicant on one side, and as a respondent on the other. So you have to prepare memorials for both sides. So usually there are 3 contentions, sometimes more than 3. The first one is on maintainability, always, unless expressly mentioned otherwise. Okay, so if you are to frame the contentions yourselves, the first one still has to be on maintainability. Again, unless expressly mentioned otherwise. What that means in simpler terms is if the problem or the rules clearly state that you do not have to argue on maintainability, you do not have to include this. The whole point about maintainability being so important is that it establishes your locus. Okay, it conveys why you get to approach the forum that you're approaching. It conveys why they have jurisdiction to even try that matter in the first place. Okay, it forms a solid base to all the other arguments that follow it. The maintainability contention is where you state that your suit or your claim is admissible, so your petition is not dismissed. The way you do it here is that you need to cite similar cases where provisions are invoked or the facts are similar to your case, and use the ratio. So Pavni and Roshni have explained what a ratio is. So you know what a ratio is, right? So ratio decidendi is the main principle that is used to draw a certain rationale or reasons for the decision. So use the ratio, connect it to the facts of your case, and plead that the petition is maintainable. Similarly, on the respondent side, judgments can be used to say why it is not maintainable. In the same manner, you argue the other contentions. You have to use references in the form of citations, books, journals, notifications, circulars, credible information, government websites to make your case. Always remember to connect your references to the facts of your case and plead using the principles that are given, but in relation to your case. Essentially, all you have to do here is connect the facts and circumstances of that case to yours and say that the same principle has to be applied here as well. That is all about arguments advanced. Now moving to citations and references. So every reported judgment has its own citation. You need to add relevant parts of the judgments to your arguments advanced and add footnotes containing the reference in the same manner as shown on the screen that is shared. Okay, the name of the judgment has to be in italics, and the other references, please quote them according to the Blue Book method of citation. Anything after the 19th edition is fine. So that is how you quote a case, or that is how you quote a citation of the case. And if you've only added the paragraph, include the name of the judgment, including the citation in the footnotes, but the name of the judgment has to be in italics. Moving on to the prayer. Thank you, Saloni. This is the format for the prayer. Okay, so prayer contains the decision or the directions that you wish to seek from the court, but very briefly. You need to remember that what you pray for is all you will get. If you have argued something for a very long time and forget to include it in the prayer, you will not get that relief. The court cannot grant relief beyond what is sought in the prayer. Okay, so this is all about the prayer, and this is the format for the prayer. Please follow it. Next, I'll be talking about the compendium. And I'll wait for Naveen to share it on the screen with you all.
Is it visible?
Yes, it's visible. Thank you. So this is the compendium. This is what the compendium looks like. Compendium is a compilation of all your annexures. It essentially has all the cases that you have referred to. Okay, it has cases, other annexures, and references that you've added in your arguments advanced in the memorial. Okay, so when it comes to cases, always prefer Supreme Court cases. Keep this in mind. Supreme Court judgments are binding and High Court judgments are only persuasive in nature. If possible, try to get cases that have been referred to in other cases. So that way it gives it more credibility. Again, it depends if the forum you're arguing before is the Supreme Court or the High Court. Okay, if you're arguing before the Supreme Court, High Court cases have very little persuasive value. But if you're before a High Court, it has a little more impact. But always try to stick to Supreme Court cases. Next, I'll be explaining the parts of the judgment. Okay, the first one on the top left corner, you see equivalent citations and the Manu citation. That is a citation you will quote as a reference in your memorials as well. So every reportable judgment has a citation. So that is a citation. Next, there is a forum where it has been decided, and it has a petition number and the date of the judgment. Then it has the name of the case. So these are the parties to the case, and this will also act like this is also the name of the case. Okay, so next there is the it mentions the number of judges in the case. So here, please remember that single judge bench orders or decisions are not binding. It has to be division bench or more, which means that there has to be at least 2 judges or more in the bench, preferably a constitution bench where there are 5 or more judges. The number of judges are usually considered when there's a conflict between the judgments of the same court used by opposing parties. So judgment with a larger bench shall be considered in that case. Next, coming to case notes. Case notes essentially summarize the whole case. So if you want to find out if the case is relevant to you or not, all you have to do is read the case notes. Next, when the judgment starts, the first few paragraphs always contain the facts of the case, the agreed facts of the case. After facts, there are arguments by the counsel on both parties. And then comes the observations by the court. Okay, now observations and findings are completely different. Observations contain obiter dictum. Obiter dictum could contain views and sentiments expressed by a judge, but they're not binding in nature. Do not use obiters to quote references in your memorials. Okay, and keep an eye on dissenting or opposing views. Opposing and minority views are not ratio decidendi. Always cite the majority view. Next comes the findings and the ratio. So ratio decidendi literally means reasoning for the case. Okay, and that is what is highlighted in the compendium. In ratio, there's always a major premise and a minor premise. The major premise is that there is a conclusion drawn with regard to a pre-existing law, and a minor premise here includes a consideration of facts of the case, and this is what you must cite. So if it involves international law, you can include conventions in your compendium, and if allowed, other data and annexures. Make sure you mark the cases and the annexures before compiling it. So this is all about arguments advanced, citations, and references. Thank you.
Thank you, Saloni and Prajwala. Now, to throw light on court etiquette, I call upon core committee member Niriksha DJ and also student coordinator Navin Ponnaya to explain court procedure and how the competition will be conducted online this time.
Okay. Am I audible?
Yes, yes.
Okay. So good evening, everybody. I'll be speaking about the court procedures. So the court manners are very, very important. So make sure that, because it's not that how you follow the general principles or the general things. It has to be specific and that needs to be followed. So please be very attentive and make sure that you follow the same. Okay, so first, as you all know, there'll be 2 teams. First, the petitioner and the respondent, or the plaintiff and the defendant, or the appellant and the respondent. So it's always the petitioner who starts the procedure. So again, as you all know, there'll be 3 members in a group. First speaker, second speaker, and then there's a researcher. So it's always the first speaker who starts the procedure. So the first speaker has to stand and then ask the permission of the court to start the procedure. And then after the judges grant you the permission, then you should start with the arguments. So subsequently, you should go before them, and then you have to introduce yourself, and you also have to introduce your co-counsel and your researcher. So this is how you will start the procedure. Think that I'm the speaker first from the petitioner side. So this is counsel first. The counsel seeks permission to approach the bench. So subsequently, the judges will grant the permission to you, and thereafter I'll go and stand before the bench. And thereafter, then I'll introduce myself. as this is how it goes. This is counsel first appearing on behalf of the petitioner, and this is counsel first appearing on behalf of the petitioner case of A versus B, and think that there are 4 issues. So first issues will be dealt by me, and the next 2 issues will be dealt by my co-counsel. So I'll say the counsel first will be dealing with the first and the second issue, and the second counsel will be dealing with the third and the fourth issue. And also you have to introduce your researcher as the non-speaking counsel. After the introduction, you have to ask the permission of the bench to state the facts of the case. So this is how you will ask again. The counsel seeks permission to state the facts of the case. The judges will permit you to state the facts of the case if they're not aware about it, if they're not well versed with it. If they're very much aware about it, they may ask you to go to the issues directly. So if they ask you to go to the issues directly, then do not worry and then go to the issues directly. If they ask you to state the facts, briefly state the facts of the case. And thereafter, after stating the facts of the case, make sure that they do not have any queries about it. Okay, so make sure that the bench is very much satisfied with the statement of the facts. So this is how you'll ask. If the bench is satisfied with the facts of the case, the counsel seeks permission to move on to the issues. So make sure that you ask the permission of the court for each and everything. So whatever you have to, that you're doing, please do it with the permission of the court. So, and then I make sure that now I presume that the judges have already permitted me to go to the issues. Okay, so thereafter you'll start with the issues. So first think that the first issue is maintainability. So then I'll state the issues and the sub issues for the clarification. Okay, so to avoid confusion, please state the issues that will be dealt by you and subsequently state the sub issues also, so that even you will avoid the confusions to the bench, so that there's a clarity. So think that the first issue is the maintainability. Then I'll say, in case of a writ petition, I'm going to state, this is the first issue being whether the petition is maintainable or not. To prove this fact, to prove this maintainability, the counsel has 3 sub-issues. First is the locus standi, the second is the fundamental rights are infringed, and the third being the alternative remedy is not a bar. So this is how you should bifurcate your issues or your argument, so that there's no confusion to the benches. And also, while you're arguing, make sure that you answer all these sub-issues. And also, while you're answering, you will cite the case laws to back up your arguments. Because unless and until you cite the cases or certain authorities, there will not be any clarifications, or there's no backup to the argument. So make sure that whenever you cite the cases, your researcher will submit the compendium. So how it will be done in the online, Naveen will tell you about that. Okay. So after the sub-issues, after the compendium submissions, you'll apply the principles of the case to the facts of the case, and you make sure that you have the legal backup to your arguments. Okay. So after now, and with the first argument, that is the first issue. So now again, I'll ask the permission of the court to go on to the next issue. So this is how I'll ask the permission. If the bench is satisfied with the first issue, the counsel seeks permission to go on to the next issue. So again, if the bench do not have any clarifications, then again, the court will permit me to move on to the next issue. Okay. Am I audible? Okay.
Yes,
so
yes.
Okay. So the judges will permit me to go to the next issue. Okay. Again, I'll state the issue as to what is the issue. And then again, I'll state the sub-issues to prove my argument. And then again, I'll cite the cases to back up my arguments. And then again, there'll be subsequently the compendium submissions will happen. Okay. So after the, presume that I'm the first speaker. Now I'm already done with the 2 issues. Okay. And again, I'll ask the court or the bench whether they have any queries or not. So if they do not have any queries, if the bench is very much satisfied with my argument, then only I can go back and the next speaker can come. If the bench have any queries, then I should make sure that I answer those points or answer those questions, and then only I should rest the case. Okay. And then see, now presume that I've done with the 2 issues, which is my part. Okay. So I'll ask the permission of the court or the court whether they're satisfied with or not. So if the bench is satisfied with the issue stated by the counsel seeks permission. The counsel seeks permission to move to the next issues, or my co-counsel will deal with the next issue. This is how I'll ask the permission of the court to move on to the next issues. Okay, and then this is how it will be done by the first speaker. So the part of the first speaker is done now. So now the second speaker has to speak from the petitioner side. Remember, so the second speaker again has to ask the permission of the court to approach the bench. Remember, whatever you do, you have to do with the permission of the court, not according to you. Okay. So again, presume that I'm the second speaker. Okay. So I'll ask the permission of the court again. The counsel seeks permission to approach the bench, because this is how I'm starting with this is where I'm starting, right? The third and the fourth issue. So I'm again approaching the court for the permission to state my argument. So again, the second speaker, the judges will permit me as a second speaker. Again, I'll go up and again I'll introduce myself as this is counsel second, appearing on behalf of the petitioner, and the counsel will be dealing with the rest of the issues. So if there are next two issues, that will be dealt by me. That is second speaker. Okay. So and then again the judges will permit me to go further, and then subsequently I move on to the third issue, and then again I'll state the sub issues, and then fourth issue, and then I'll state the sub issues again. So this is where the part of the arguments are done. And next comes the main part, that is the prayer. So the relief that you're seeking has to be very much clear, because in moot court, that is where you get screwed up most of the times. Because if your relief is not clear, or if you're not clear about what you're seeking, then you'll get screwed up. So make sure that your reliefs are very clear, and also the judges do not have any questions. There are no loopholes in it. So the judges will point out and then ask you the question again on the prayer. Okay, this is where the petitioner's part will end, and the same procedure will be followed by the arguments. I'm very much sorry, by the opponents. Okay, your opponents might be the respondent, or the if it is defendant, plaintiff and the defendant, then there'll be defendants, or your appellant and the respondents means the respondent. Even they will come up and they will follow the same procedure. Think that I'm the first speaker from the respondent side. Again, I'll ask the permission of the court. Okay, so the counsel seeks permission to approach the bench. Again, I'll go and I'll introduce myself as counsel so and so in the case of so and so, and again the issues that will be dealt by me. Okay, and also my co-counsel, that is your teammate, and also the non-researcher. The non-speaking counsel, that is the researcher. Okay, the same procedure will be followed throughout. That is the end of the competition. And next, till the procedure ends, you have to follow this procedure. Okay, so make sure that you're giving the respect to the bench, because the court is a temple of justice and it is not the same. It's a very general place. So make sure that you are giving the respect to the court and the bench, and also whatever you're doing with the respect. Okay, do it with the respect. And then the main arguments will end. And next, there'll be rebuttals and the sur-rebuttals. So what is rebuttals and sur-rebuttals? Rebuttals is basically you rebut the points of your opponent. So if the main arguments of the respondents will end. Then the petitioner side will get the time for the rebuttals. Okay, so first, if I'm the petitioner, either one of us can do the rebuttals. So after that, after the end of the argument of my opponents, then I'll stand up and have the permission of the court to rebut points, or whatever they have said in their argument, not in the memorials. Make sure that you can rebut whatever they have said, whatever your arguments, and not whatever they have stated in the memorials. You cannot point the mistakes of the memorials offense. Okay, you can only point out the mistakes, whatever they've done in their arguments, and not in the memorials. So you have to limit your rebuttals to the arguments. You hardly get 1 minute. So you make sure that you rebut all the points, that whatever they have alleged on. So if I'm the speaker first of the petitioner, so that I can rebut. So again, I'll ask the permission of the court to rebut the points, whatever they've said. So I'll go and I'll cite 2 or 3 points where I think that I can rebut it. Okay, where I think that there's a point, or where I can say that I have the authorities I can cite the cases so that I can rebut their points, or I can answer the questions, whatever they have said, it is unanswered. Okay, that is basically what you do in rebuttals. So subsequently, your opponents will also get the chance for the sur-rebuttals. That means the respondents will get the chance for their sir rebuttals, saying that I'm the respondents now, so I'll get the permission. Now I've already seek the permission of the court. Now I've already got the permission from the bench to sir rebut the points. So now I have to come up and sir rebut whatever they have stated in the because you've already rebutted the points, whatever they have stated in. Okay, so make sure that your sir rebuttal is limited only to the rebuttals. So you can answer the questions whatever they have said unanswered, or you can rebut whatever they have said in their rebuttals. Okay, I hope these are clear. And now I'll state certain points where you have to, where if you, I mean, where you have to follow the court manners, although there are specific terms which you have to use. Okay, you cannot use the general term. So say like the bench will ask you the question and you do not know the answer for it. Okay, say the counsel pleads for ignorance. I'll repeat, the counsel pleads for ignorance. Do not say I do not know the answer for the question. Say counsel pleads for ignorance. And also, if you think that your teammate can answer the question, say that the co-counsel will get back to the question. If you say that, make sure your co-counsel will answer the question, then go to her argument. Okay, say, so in between, if the bench asks you questions, say if you do not know, say counsel pleads for ignorance. And also during the arguments, if you think that you have wrongly mentioned any provision, say for example, I have to state Article 32. Instead of that, I stated Article 226. So I realized then and there that I have made a mistake. So say that the counsel stands correct. Do not say I'm sorry. Say counsel stands correct. Okay, this is the manner, this is the term that you have to use. And then if you do not say yes or no directly to the bench, say indeed or indeed not. If you think that that you have to defer to the whatever the points that the judge has said, say the counsel begs to differ or indeed not, your lordship. Say like this, say do not say yes or no directly to the bench. And also if you say that you did not get the question, basically say pardon, they might repeat the question. Okay, so they will repeat the question. Do not, and also be humble as possible, because as already mentioned, it's a temple of justice and the people that are in the bench are very eminent persons. So make sure that you give enough respect to them. Do not argue with the judges. Okay. So these are the court manners and the procedure that you have to follow in a moot court competition. And also moot court, whatever I have stated right now has to be stated. Okay, there is no exception for it, or there is no excuse for it. You cannot say sorry, ma'am. Those, so in a moot court inter-class competition, what happens? Some of our faculties will be a judge for you, but you cannot say ma'am or sir. You have to address them as your lordship or as your ladyship. Okay, if there is a female member on the bench. So this is how you have to address them, and this is how you have to follow the procedure. And also the court manners carry the point. So make sure you keep all these points. Make sure you have to keep all these points in your mind so that it will be followed throughout your 5 years. Okay. So, and also there is no excuse for it, as I've already mentioned. It carries marks. So make sure that you have to say it. You have to state all these points. So now Naveen will say, explain you about how the online, this time it is online. So he will be explaining about how the online moot will go on. So over to you, Naveen. Thank you.
Thank you, Niriksha. So good evening, everyone. I am Naveen Ponnaya from 10th MBA LLB and one of the student moot court coordinators for this year. And I'll be dealing with how this moot competition will be held online this time. So is it visible?
Yes.
Yes,
Oh.
it is.
Okay. So as you all know, this is the first time that JSS Law College is conducting the intra-collegiate moot court competition completely online. So I'll be dealing with the technicalities as to how it will be done. The registration and clarification forms have already been provided with the Moot proposition. There are teams who have already registered and clarifications are already coming. So make it a point you go through and fill the registration form properly, because in the registration form we have asked two things. One is your number and one is the mail ID, which is very much important, because the person who have given their number will be added to a separate group which will be created for this whole and solely for this stasis intra-collegiate moot court competition. So any updates or any announcements will be shared in that group, and that person who is in that group is whole and solely responsible to communicate the same to your teams. So make sure that person or the number which has been given is proper. Next, the instruction for submissions of the memorials. As Prajwala and Saloni described as to how important the memorials is. So submission of the memorials, the rules and regulations have been already provided with the rules and regulations with the Moot proposition. So kindly go through the rules and regulations so that the memorials you submit will be in time and will be in a proper way. Now coming to the technicality, so once your memorials are submitted, the next part is drawing of lots. So to those people who don't know what is drawing of lots, it's nothing but a fixture wherein let's say 10 teams have, let's say 40 teams have registered. So we have to determine which team goes against which. So earlier when it was offline moot, what we used to do is the chits would be picked, and based on the chits, the fixtures will be allotted, that which team goes up against which team, that would be identified. Now since it is online, we have a online portal, that is we have an online portal wherein if 40 teams are there, all the 40 teams team codes will be put into the online portal. So when we click or when we make sure that it is the process is complete, the online portal itself will give the fixture, that is the team 1 will go against team 40 or team 2 will go against team 22. It is not us who is identifying it, so it is just the online portal which is going to be doing that, and that will be deduced into fixtures so that there is much of transparency. And how this will be done, Google Meet a link like how it is being done today, the same way a Zoom link will be shared to all the participants, like 40 teams. If there are 40 teams, then 40 participants will be allowed to get into that Zoom link, and in front of them this website or the online portal will be run, and then and there itself the teams will get to know the fixtures or the lots. In case if you are not able to identify, if you're not able to understand the fixtures, or if you're not able to grasp it, then the same will be deduced into PDF format and will be put it in the group, so that the teams will not have any confusion. So as far as drawing lots are concerned, online portal, the team codes will be uploaded, and the online portal itself will give back the fixtures. So which team will go against which team will be decided by online portals. So the next thing after the drawing of lots is the researcher test. So basically the researcher test is nothing but wherein the researchers of each team will be given a written test. If it was online, it would have been in a written test wherein it depends on the questions. Like it might be fill in the blanks, or it might be choose the correct answer, or else it might be an essay type answer. So that is how we used to do. 1 hour would be given, certain questions would be given, and based on the answers provided, the best researcher would be identified. So since this time it is online, it is easy for those people who have already attended legal quiz, which was done by Moot Court Club. So it was done through a website named Quizzes. So wherein the questions will already be uploaded. It depends. It depends. It might be a fill in the blanks. It might be true or false. It might be choose the correct answer, or else it might be an essay type answer. It depends on the questions, and based on the questions and the difficulty of the questions, the time will be allotted, like 10 seconds, 20 seconds. So let's consider it is a fill in the blanks, or let's consider a choose a correct answer question. A question is there, 4 options are there, so you have to select one option among them. The question is bit easy, so there is 20 seconds time limit. Within 20 seconds you have to click the correct answer and you have to move on. In case a student fails to click the correct answer within that 20 seconds, the student will be taken to next question, and that question the students will not be allowed to re-attend it. So make sure you see the timings of the questions and then you answer, because within the time frame within which you answer is also very important, because even that will be considered when scoring. So this will be done through an online website named Quizzes. Login will be provided, wherein the team researcher has to log in with their team codes, not with their names, not with the researcher. They have to log in with their team code so that we can identify the which team researcher has come and which team has won the best researcher award. So once they enter, the questions will go on. Once they finish, they have to log out. A researcher cannot attend the same test twice. If it is found that any researcher is attending the same test twice, that researcher will be disqualified from the researcher test, or else some consequences they'll get to see. And then once the researcher test is done, how the marking will be done is the online portal itself gives out the marks. The marks will be decided on two criteria. One is the right answer which you have given, and the second one is the time frame within which you have answered. Both are important, so make a note of it. So I'll be showing the result sheet as to how we'll get so that you'll understand. So this is the actual result sheet. These are the questions on the left side. These right side where you see the green marks, those are the right answers given by the contestants. These the red marks, the red answers are the ones which is wrong. So name of the student here, you'll get the names A, B, C, D, E, like Naveen Ponnaya, Prajwala, Saloni, Pavni, Rula, like that you'll get. So at the end of it, below, the based on the correct answers and based on the time frame within which you have calculated, within which you have answered, the total scores will be provided. So based on that, the best researcher will be decided. So this is researcher test, which will be online. So the next part is allotment of courtrooms. So let's say 40 teams are there. So 40 teams, in the sense we have to create 20 courtrooms. So on the day of the competition, allotting courtrooms is difficult. So what this time we have identified is we'll allot the courtrooms. First of all, this whole as of now, the whole moot court competition will be conducted through Google Meet, because Google Meet we don't have time restrictions, and that is one of the more important aspects. So it will be conducted through Google Meet. So what we'll do is 1 or 2 days prior to the competition, a Google Meet room will be created, and the same ID will be shared with you people. So a tentative list has been provided here. So on the right side, on the right side, you can see the tentative list. So first column is team codes. That is according to the fixture, which team is going on which. That is team 1 is going against team 11 in this case. So the courtroom codes which have been created, the courtroom codes have been provided in the second column. Third column is the court officer who has been allotted to your respective courtrooms, and fourth column is the bench clerk who has been allotted to your respective courtrooms. So these two numbers, the court officer and bench clerk number, we have provided just to make sure that there is no difficulty for the contestants to sort out any technical issue. So if you have any technical issue or if you have any doubt, then you can contact those court officer or bench clerk to clarify your doubts. So this is how it will be. 1 or 2 days before, courtroom will be created and courtroom codes will be shared in that particular group in this particular column, and the timings will also be indicated. So this is allotment of courtroom. So 1 or 2 days prior only, you will get to know the courtroom codes, so that it will be easy for you people to log in and there will be no confusion at all. Next is the allotment of courtrooms is done. Next is the actual competition, like on the day of the competition, on the day of the rounds, what needs to be done. So first thing is, team shall have to log in 10 minutes before the commencement of their rounds. Both sides, 6 participants have to log in 10 minutes or 15 minutes before the round, so that if there is any technical issue, then you can sort it out. Okay. The second thing is, while logging in, you have to log in with your designation and not with your names, like the team codes. Like for example, we have given here, the team code here is T12, the petitioner side, and the researcher is logging in. So what you're supposed to do is, T12 is your team code, petitioner is mentioned there, and researcher. If it is speaker 1, it is, instead of researcher, it is speaker 1. Instead of if it is speaker 2, then instead of researcher, it is speaker 2. Make sure you log in with your correct ID. Failing to do so, it will be difficult for us also to mark you based on the arguments you do. So your team codes, your designation is very much important while logging in. And one more technicality issue here is, in Zoom, it is very easy to change your username or ID. So in Google Meet, it is a bit difficult. So we have identified a method. So it is, you have to log into your email ID. Once you log into your email ID, you go to the settings option wherein manage your accounts will be there. Once you go into the manage your accounts, a personal info tab is there wherein you can change your designation. So for the time being, when the rounds are going on, you just change your designation to T12 petitioner researcher. And once the rounds are done, you can change it back. But remember, if you are going from prelims to octa to semis, the same has to be carried out. And for your regular classes, you can just change it back later. So once logged in, remember, courtroom will have one court officer, two bench clerks, such number of judges allotted to the said room. Like it might be a single judge bench, it might be a divisional bench, it might be more number of judges. That is left to the discretion of the Moot Court Club Society. And then 6 participants, 2 speakers and 1 researcher from the petitioner or appellant or plaintiff side, 2 speakers and 1 researcher from the defendant, respondent, or like this. So once logged in, everybody is settled and everything is done. So right side, you can see an image wherein a participant, that is a participant has, that is the researcher of the petitioner side, team 12. This is just an example. The example which you have given in the description is how you have to log in. This is just an example to show how it will be shown in the, so how convenient we'll be there. So once this is done, the courtroom will be like this, like how you see in your classes. So once everything is done, the bench clerk will indicate the commencement of the rounds. Then the speaker, like how Niriksha said, the council seeks permission to approach the bench. Then the speaker can come up. The speaker can introduce their speaker to and the researcher, and then ask for facts. If facts are done, then they can go on with their oral pleadings. So while going on with the oral pleadings, presiding judges will have the liberty to unmute and ask questions whenever they want. In between your oral pleadings, they can stop you and ask questions. Make sure whenever the judges unmute and speak, make sure you stop your oral pleading, listen to their question, address the question, give answer. Or else, if you don't know the answer, if you say that co-counsel will be dealing with the same question, then you address the question first and then you move on with your arguments. You can't just blatantly ignore the questions which has been put forth by the judge. So make sure you hear the judges, make sure you answer the question and then move on. So once this is done, let's say the speaker one is giving their oral pleadings. So while giving their oral pleadings, there are instances wherein the speaker is going to refer to cases. Now, in an offline stage, wherein what we used to do is when a speaker refers to a particular case, this researcher would pass on the compendium, which would be compiled and spiral binded. The same would be passed on to the judge so that the judge can have the look at the particular lines of the judgment from which the speaker has taken the lines. But now, since it is online, we are not able to provide the judges with a physical compendium. So what we have done is the researcher of the teams, like let's say the petitioner or the appellant, who are arguing first, and speaker one is going with their pleading, and one case law is referred. The researcher of the petitioner team or the appellant team will be given the permission to screen share. So if the permission to screen share will be given, so what the researcher has to do is the particular relevant page which the speaker is referring, so that has to be screen shared to the judges, so that the judges who are judging the moot court competition, like how you are seeing this slides, like in the same way they'll get to see the compendium. So once the judges see the compendium, they'll be doubly sure that your arguments or the cases you're referring is proper. So that has to be done. The researcher is the only person who has the liberty to share the compendium and make sure that the case which the speaker is referring, the same compendium or the same sheet or the same case is being shown in the compendium. You can't jumble up because it is not physical moot wherein you can just turn pages. So here you have to be very precise. And one more thing is, while putting the judgments in the compendium, you have to mention the whole case. Like let's say, like there are judges who say that the whole case has to be mentioned. So what you have to do is the front sheet along with the whole judgment has to be there. If the judgment is 20 sheets, you have to put the front sheet along with 20 sheets. It is not just the operating part of the sheet which you have to put. So make sure you put the whole 20 sheets. So this is one thing. So this is the compendium, sharing of compendiums. So bench clerks will be interested with the responsibility to ascertain the remaining time and convey the same to the speaker. For those who have not attended Moot, let's say a speaker has 15 minutes. Okay, so 15 minutes he's speaking, provided that 15 minutes the speaker has to keep some time for rebuttal. Let's keep it aside, let's not complicate. The speaker has 15 minutes. So 10 minutes the speaker will speak. The bench clerk, after 10 minutes, only 5 minutes will be remaining for that speaker to complete their oral pleadings. So what the bench clerk will do is, when it was an offline Moot, bench clerk will just get up and show the placard saying that 5 minutes remaining. Okay, then the same will be done for 2 minutes remaining and time over would be shown. But since this is online Moot, the bench clerk just if the bench clerk shows the placard, it will not suffice. There are chances that speakers who will be concentrating on their oral pleadings might not see. So what we have done this time is we'll ring the bell. One bench clerk will ring the bell and one bench clerk will show the placard. So 15 minutes is the time, 10 minutes the person has argued. So after 10 minutes, the one bench clerk will show a placard of 5 minutes remaining and a short bell will be rung. So that is the indication that you have only 5 minutes remaining. The same when it comes to 2 minutes remaining, 2 minutes placard will be shown and 2 small bells will be rung. Then after 2 minutes, time over gaya, 1 long bell will be rung. So after that, if the speaker wants to extend the time, if the speaker asks that the council seeks permission to extend the time by 1 minute. So after 1 minute, again a long bell will be rung. So this is how the bench clerk will show the time remaining and not. And then as once speaker 1 has finished his or her oral pleading, speaker 2 will present his or her oral pleading followed by the prayer. The same thing will repeat. The same process will repeat for the other side as well. Based on the time reserved by the speakers, the bell will be rang for rebuttals and sur-rebuttals. So once the whole thing is done, both of the teams are done arguing, both of the teams will be kindly asked to leave the courtroom, so that the bench clerk and the court officers who are sitting inside the room can assist the judges and to make a note of the marks which has been provided. So, and subsequently the results will be announced later. So this is how the whole process we have planned as to how the Moot competition will take place. And since this is totally technical, if there are any changes, the same will be updated in the Moot in their respective Moot groups. So this is how the competition is going to go on. So now I'll end my presentation and I'll hand over the meeting to Rula. Thank you all.
Thank you, Niriksha and Naveen. Before we proceed to demo, I want to say also present in this meeting are Court Committee Faculty Coordinator Ashwini ma'am and Court Committee members Surya Patel and Anudip Jain from final year of BBA LLB and Lisma Joshua from 3 years LLB final year. Now we will move forward with the Moot demonstration. The bench consists of Niriksha DJ and Ashwini ma'am. Pavni Randeo and Surya Patel are the bench clerks who are in charge of keeping the time. The petitioners team consists of Lisma Joshua as speaker 1, Saloni Oliveira as speaker 2, and Anudip Jain as the researcher. The respondents team consists of Roshni Purnama as speaker 1, Prajwala Satyaprakash as speaker 2, and Naveen Purnaya as the researcher, and I will be the court officer. Let the proceedings begin.
The court proceedings shall begin now.
The counsel seeks permission to approach the bench. Much obliged. The counsel seeks permission to address the bench as your ladyship. Much obliged. Your ladyship, this is counsel number 1, appearing for the petitioner in the case of Harvey Dent versus State of Karnataka. The counsel will be arguing for 4 minutes and the co-counsel for 5 minutes. 1 minute will be reserved for rebuttal. The counsel will be dealing with issue number 1 in her arguments and the co-counsel will be dealing with issue number 2. If your ladyship are well aware with the facts of the case, the counsel seeks permission to proceed with her argument.
Proceed with the issues.
Much obliged. Your Ladyship, the Council will be placing her arguments for issue number 1. Issue number 1 being whether the petition is maintainable. It is humbly submitted before the Honorable Court that the writ petition in the instant case is maintainable. A writ petition to be maintainable requires locus standi, which means the power to stand before the court. In the case of S.P. Gupta versus Union of India, it was held that the basis of entitlement of judicial redress is personal injury from violation of the legal rights or legally protected interest of the person seeking such redress. Thus, as a general rule, whose fundamental rights had been infringed can apply to the Supreme Court under Article 32. Further, in the case of S.P. Gupta, it was held that if a person who has a genuine grievance on account of an action which affects him prejudicially is ordinarily considered to be eligible to move the court. In the instant case, the fundamental rights of the petitioners guaranteed under Part 3 of the Constitution are at stake. Hence, it confers upon them the right to approach this honorable court under Article 32 of the Constitution. It is humbly submitted before this honorable court that this petition is maintainable.
Ms. Counsel,
Yes, yes, Your Lordship.
how do you say that fundamental rights of the MLAs are infringed?
Your Ladyship, the fundamental rights of the MLAs have been infringed under Article 14 and Article 19(1)(g) of the Constitution. The Speaker has acted in a malified and arbitrary manner by not accepting the resignations of the MLAs. Under Article 190 of the Constitution, read with Rule 202 of the Karnataka Legislative Assembly, the Speaker is only to satisfy with himself with the genuineness and the voluntariness of the resignation of the MLAs, neither of which have been disputed in the instant case. Further, in the case of Babita versus State of Bihar, if the action of the state can be shown arbitrary, then notwithstanding any classification, it would offend Article 14 and is liable to be struck down. Here, the delay in acceptance of resignation has no valid reason, and hence it can be stated that the inaction of the Speaker is malified and arbitrary in nature. Therefore, there is a violation of rights under Article 14 of the Constitution. Further, the petitioners also have a fundamental right under Article 19 of the Constitution, 19(1)(g), that is to carry on any trade, business, and profession. This also includes the right to resign from the post of MLA and carry on any vocation of their choice. And this is being denied by the Speaker by delaying their acceptance of the resignation and in a completely illegal, arbitrary, and unconstitutional manner. Hence, there has been a violation of the fundamental rights. If your Ladyship permits, the Council would like to call upon her co-counsel to proceed with the second issue.
Proceed with the next issue.
Much obliged.
Your Ladyship, the co-counsel seeks permission to appear before the bench.
Proceed.
The council seeks permission to proceed with their arguments.
Proceed with the argument. Proceed with the argument.
Your Lordship, the council will be dealing with issue number 2. The issue number 2 being whether the Supreme Court can interfere with the functioning of the Speaker of the Legislative Assembly. It is most humbly submitted for this Honorable Court that the Supreme Court can interfere with the functioning of the Speaker of the Legislative Assembly. Your Ladyship, the Council will be proving this statement in her various sub-contentions. This first contention being doctrine of separation of power not strictly construed. Your Ladyship, in India, the doctrine of separation of power has not been accorded any constitutional status apart from directive principles of state policy laid down in Article 50, which enjoins separation of judiciary from that of the executive. The constitution scheme does not embody any formalistic division of power. So, in no provision of the law, there is express separation of power that is provided. The second sub-issue being judicial review as a basic structure. The task is to check here basically what judicial review means is that the court's power to check on the constitutionality of any act or a statute or anything done that violates the provisions of the Constitution. Thus, the judicial review is the power of the court to determine whether the acts of the legislature and executive are consistent with the constitution or the constitutional values. Your lordship, your ladyship, in the case of state of West Bengal versus Committee for the Protection of Democratic Rights, the Supreme Court has laid down that the Supreme Court has laid down that when there is jurisdiction conferred on this court under Article 32 and the High Courts under Article 226 of the Constitution, the power of judicial review being an integral part of the basic structure of the Constitution, no act of the Parliament can exclude or curtail the power of the Constitutional Court with this regard to the enforcement of fundamental rights. As a matter of fact, such power is essential to give practicable content to the objectives of the Constitution embodied in Part 3 and other parts of the Constitution. So, your ladyship, it is important to note that as the co-counsel already put forth before this honorable court, that there is a blatant infringement of fundamental rights, and therefore this constitutional court has all the power to interfere with the functioning of the Speaker of Legislative Assembly. Your ladyship, the next sub-issue being whether the doctrine of power...
Counsel.
Your ladyship.
When there's a specific provision in the law which bars the interference of the court, how can you approach this court to interfere with the procedure again?
Indeed, your lordship, the council agrees that there is a provision provided in the constitution, that is Article 212, that bars this court's interference with the functioning of the Speaker of the Legislative Assembly. However, your ladyship, it is very pertinent to note that as it was stated in Raja Rampal's case, it blatantly states that when there is only when there is irregularity of the procedure, this court is barred from interference. However, when there is blatant illegality in the procedure, that is in this case, wherein the MLAs have submitted their resignation form prior to the disqualification petition that was presented by the party members, and the speaker kept on hold, and instead of deciding on the resignation letters, the speaker went on to initiate disqualification proceeding, your ladyship, which itself shows that there is illegality in the procedure, that is illegality in the conduct of the speaker, and therefore this court has all the powers to interfere with his functioning, your ladyship. If your ladyship permits, the council would seek permission to move on to the last contention. The next sub-contention being whether the doctrine of separation of power curtails the power of judicial review. Your ladyship, in the same case, that is State of West Bengal versus the Committee for the Protection of Democratic Rights, the question arose whether the doctrine of separation of the power curtails the judicial review conferred on the constitutional courts, even in situations where there is violation of fundamental rights. So here in this case, the Supreme Court held that the guardians and the interpretants of the Constitution who provide remedy under Article 32 and 226, whenever there is an attempted violation of fundamental rights, cannot be immunized from judicial scrutiny under the touchstone of doctrine of separation of power, your leadership. Therefore, the council submits that this honorable court has all the powers to interfere with the functioning of the Speaker of Legislative Assembly. If your ladyship permits, the council would like to present her prayer.
Proceed with the prayer.
Much obliged. Wherefore, in the light of contention presented, arguments advanced, and authority cited, the counsel for the petitioner most humbly and respectfully pray before this Honorable Supreme Court of India that it may be pleased to declare and adjudge that the writ petition is maintainable. The Supreme Court can interfere with the functioning of the Speaker of Legislative Assembly. The counsel for the petitioner also prays before this Honorable Court to direct the respondent to decide on the resignation letters. The court may also pass any order as it may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, your ladyship, petitioner as duty bound ever humbly prays.
The counsel seeks permission to approach the bench. Much obliged. Greetings to the bench. The counsel seeks permission to address the bench collectively as your ladyship. Much obliged. Your ladyship, this is counsel on behalf of the respondent in the case of Harvident and others versus the Speaker Karunadu Legislative Assembly. The counsel will be dealing with the first issue, taking 4 minutes, and the co-counsel will be dealing with the second issue, taking 4 minutes, thus reserving 1 minute for the sir rebuttal. If your ladyship is well versed with the facts, the counsel seeks permission to move to the arguments advanced.
Proceed with the issues.
Much obliged. Your ladyship, the first issue being whether the petition is maintainable. It is humbly submitted before this honorable court that the said writ petition is not maintainable because there is no locus standi. The writ petition is filed under Article 32 of the Indian Constitution, is maintainable when the authorities fail in its duty in protecting the fundamental rights of its citizen, that is envisaged in the Part 3 of the Constitution of India. However, in the instant case, the Speaker in no way failed in his duty and the fundamental rights of the petitioners has not been infringed. Your ladyship, the respondent in the case has acted as per his jurisdiction and power and asked for the specifications to be met as required by the law. Your ladyship, there is no locus standi under Article 32 if the fundamental rights have neither been directly and substantially invaded nor are in imminent danger of being invaded. The respondent at the instant case merely asked the petitioners to resubmit the letter of resignation as they were not in the prescribed form. Further, there are two conditions for an MLA or MP to tender resignation. First being, the resignation has to be drafted in the official format and it has to be brief. The second condition being, the resignation should not be tendered under pressure. If the Speaker finds ambiguity in these two conditions, then he shall act upon it as he deems fit. In the case at hand, the respondent has acted and exercised his power to perform his duty as there was no proper prescribed form was followed by the petitioners. Your ladyship, referring to the case of Ramdas Atwale versus Union of India and others, para number 3739, it was held that there was no infringement of any fundamental rights that is envisaged in the Part 3 of the Constitution. And the court reiterated the principle that whenever a person complains or claims that there is violation of any provision of law or constitutional provision, it does not automatically lead to the infringement of the fundamental right under Article 32 of the Constitution. Referring to para 39, the
Ms. Counsel.
Yes, your ladyship.
How do you say that the fundamental rights of the MLAs are not infringed? Are you saying that the MLAs do not have the right to resign?
Your ladyship, there is the fundamental rights have not been infringed as right to resign has not been envisaged under Part 3 of the Indian Constitution. Moreover, the Speaker, the respondent has not denied the petitioners from resigning. Your ladyship, the respondent has just asked the petitioners to resubmit the resignation letters in the proper format as it is required by the law. The Speaker has not taken the final decision, so the interference of the court cannot be sought for. So thus bars the jurisdiction of the court. The petitioners have formed the group by themselves to overthrow the government and also to escape the liability of being put forth before the disqualification proceedings that is pending before them. Also referring to the case of MSM Sharma versus Dr. Sri Krishna Sinha and others, the Supreme Court held that no court can go into those questions which are within the special jurisdiction of the legislation itself, which has the power to conduct its own business. That the respondents in this case has not failed to comply in its duty, but exercises power in its jurisdiction so that the petitioners submit their resignation letter in the proper manner. Hence, it is humbly contended before this honorable court that relying on these submissions, the petitioner has no locus standi and the lit petition is not maintainable. If your ladyship is satisfied, the council seeks permission to call upon the co-counsel to deal with the second issue.
Yes, proceed with the next issue.
Much obliged.
Counsel seeks to approach the bench.
Proceed.
Much obliged. The counsel seeks permission to address the bench as your ladyship. This is speaker number 2 on behalf of the respondent seeking permission to proceed with the second issue.
Proceed with the issue.
The second issue is whether the Supreme Court can interfere with the functioning of the Speaker of a Legislative Assembly. Here, the respondents humbly submit that this court cannot interfere with the functioning of the Speaker in a Legislative Assembly. It would be in excess of jurisdiction of this Honorable Court to do so, especially when the matter has not been decided by the Speaker yet. So when the Speaker is considered as a quasi-judicial body, it would be in violation of the legislative lines if this Honorable Court were to interfere in the proceedings midway. It is also contended that it is wrong to state that when the MLAs had come to offer resignation, the Speaker wasn't in town. The respondents bring on record to only show that the petitioners have misled the court and the resignation was nullified altogether. The Speaker here had the constitutional duty under Article 190, Clause 3b to ensure that resignations were voluntary and were not caused by any coercion or inducement. The court has limitations in issuing directions to the Speaker in respect of conduct of proceedings in-house. Hence, the respondents humbly argue before this court, asking this court to refrain from passing any specific directions to the Speaker. Moving on to the next sub-contention, which is acceptance of resignation is a matter of Speaker's... Yes, Your Ladyship.
Are you saying that the Speaker's decision is final and the Supreme Court cannot question it?
Your Ladyship, the Speaker in the present petition was performing his constitutional duty in examining if the resignations are in good faith. It is a procedure under the 10th schedule beyond the purview of the House. This is only one such case where the Speaker was assigned a deadline to decide on the resignations. In the decision of Quixote Holohan clearly stipulates that this court can only review the Speaker's call after he has taken such decision. It would be wrong for the court to dictate a deadline on or say how the Speaker should go about it. Your Ladyship, para 6 and 7 of the 10th schedule of the Constitution of India, the jurisdiction to declare a member of the Legislative Assembly as disqualified is solely vested in the Honorable Speaker of the Legislative Assembly or the Chairman of the House, as the case may be. Since his decision is the final one, the power of judicial review is rather limited, even after the Speaker takes the decision. In Quixote Holohan's case, again, the court held that while the decisions taken by a Speaker is subject to judicial review, no quia-timate actions are permissible against the Speaker. Therefore, this court can neither direct the Honorable Speaker to decide in time-bound period, nor can declare the members of the Legislative Assembly as disqualified. Your Ladyship, if one examines the constitutional scheme, it becomes clear that acceptance of resignation by the Speaker is not a matter of right of a legislator, I beg your pardon. It is the Speaker's discretion. It is clear from the proviso to Article 190, Clause 3b of the Constitution, which says that the Speaker shall not accept the resignation if he is satisfied that it was not voluntary or genuine, or in this case, the format for the resignation was incorrect. From the plain text of the Constitution, two things follow. The first one being that the resignation is not a matter of right of an MLA. It is not a fundamental right. It is only a constitutional right. The second one being that a political party has power to direct its member to be present in voting. Your Ladyship, the council seeks an extension of 1 minute in the interest of justice.
Yeah, you have 1 minute.
Much obliged. So a political party has power to direct its member to be present in voting in-house, and non-compliance of such a direction will lead to the member's disqualification on the ground of defection. At one point, the Learned Counsel for the petitioners argued in our favor, and the respondents are very grateful for that. Like they said, Article 212 clearly states that courts are not to inquire into proceedings of the legislature on any ground of any alleged irregularity in procedure, and no officer or member of the legislature of a state in whom powers are vested by or under this Constitution for regulating procedure or conduct of business or for maintaining order in the legislature, it shall only be subject to the jurisdiction of any court in respect of exercise by him of those powers. I mean, what the council means to say here is that the jurisdiction of the court is not drawn here. The speaker, your ladyship, was only performing his constitutional duty and examining if the resignations are in good faith. In Mayawati's case, the Honorable Supreme Court has referred to Quixote Holohan and has held that the 10th schedule expressly confers power to decide on disqualification to the speaker, and that such decision of the speaker is final. Considering all of this, your ladyship, the respondents humbly pray for this honorable court to dismiss the present case at the earliest. If your ladyship is satisfied with the arguments, the council would like to move on to the prayer.
Move on to the prayer.
Much obliged. Wherefore, in the light of issues raised, arguments advanced, and authorities cited, may this honorable court be pleased to dismiss the petition against the respondents, declaring it to be infructuous, to declare that the speaker has not acted arbitrarily, to adjudge that no intervention of this court is required until the final decision of the speaker, or pass any other order it may deem fit in the interest of justice, equity, and good conscience, all of which is most humbly and most respectfully submitted. For this act of kindness, the respondent shall duty bound forever pray. Much obliged.
Your ladyship, the council seeks a minute's time to present her rebuttals.
Yes, you have 1 minute.
Much obliged, your ladyship. Your ladyship, the learned counsel for the respondents argued that there is no violation of fundamental rights and therefore this petition is not maintainable. However, the council presents that there is blatant violation of fundamental rights in this case, as the under Article 14 it states that the differentiation can be done only on the criteria of intelligible differentia, and in this instant case, even though the annexure to the proposition, your ladyship, gives out the format in which the MLAs have submitted the resignation letters, and it clearly states that all of them had submitted in the same format. But here the speaker has sent back a few of the resignation letters and kept few of them, saying that they were not in the correct format, which violates the provision under Article 14, and therefore it is in violation of fundamental rights. Again, talking about Article 19(1)(g), which gives right to trade and occupation, your ladyship, the MLAs, just like any other occupation, are the servants of the public, and they have the profession of serving the public, and therefore it is their fundamental right to resign from the post whenever they deem it not in their favor. That is, whenever they feel that their article, that is their integrity, is being infringed with. Therefore, as per their right under Article 19(1)(g), they submitted their resignation letters. This shows that there is a blatant violation of fundamental rights, and therefore, coming to the second issue, your ladyship, the council seeks 30 seconds to conclude her debates.
You have 20 seconds.
Much obliged, your ladyship. Your ladyship, the council agrees that there is a provision under the constitution barring the interference of this court. However, that provision, that is Article 212, clearly states that this court cannot interfere only when there is a procedural matter. However, your ladyship, procedural irregularity, but as the council already presented, that in this case it is the illegality that is being questioned. That is the principles of natural justice of the MLAs have been violated, since under Rule 7 of Karnataka Legislative Assembly, disqualification on the ground of defection rules clearly states that before initiation of any disqualification proceedings, a show cause notice has to be given to the MLAs, which was not done in this instant case, and the procedure was begun. Therefore, your ladyship, the council concludes her arguments stating that this court has power to interfere with the functioning of the Speaker of Legislative Assembly. Much obliged, your ladyship.
Your ladyship, the counsel for the respondent would like to approach the bench for saw rebuttals. Yes, you have 1 minute. Much obliged, your ladyship. Your Ladyship, inequality here is shown because there is a certain format for tendering the resignation, and the same has not been followed by the petitioners. Their whole contention of Article 14 being violated is hence absolutely baseless. No principles of natural justice have been violated. No fundamental rights have been breached as well. The petitioners really need to understand the fact that the right to resign is clearly not a fundamental right. In addition to this, the council would also like to state a case here, which is Jagjit Singh's case. Here, the Supreme Court has observed that the Speaker, while exercising the power to disqualify members under the 10th schedule, acts as a tribunal and the scope of judicial review is limited. The orders can only be challenged on the grounds of ultra vires or malefice or having been made in colorable exercise of power based on extraneous and irrelevant considerations and not otherwise. But in the instant case, the Speaker has not even taken the final decision. Now, what the petitioners here very humbly pray for is for this honorable court to completely vandalize the theory of separation of powers. It's rather odd, Your Ladyship, when the order is in their favor, they do not have any complaints. There is no rule on the extent of powers of this court. To try and trap the parameters of the Supreme Court within inflexible limits is totally abhorrent to the Constitution. The petitioners have very apparently not approached this court with clean hands, which is why we pray for this before this honorable court to dismiss the petition at the earliest. The counsel for the respondents thus concludes her rebuttals. Much obliged.
Lola?
Yes, that was the end of the Moot demonstration. Now I'll move on to concluding remarks. I would like to take this opportunity to express my sincerest thanks to the Chief Executive, Professor K. Suresh, and Principal Dr. S. Nataraju for their continuous support towards the Moot Court Society. I would also like to express gratitude towards Ashwini ma'am for her constant guidance and support. Also, I would like to sincerely thank Madhu sir for lending us his technical prowess and assistance. Furthermore, I would like to thank the Moot Court committee members for all their efforts and hard work in making this online training session a success. Last but not the least, I would like to thank the audience for keenly tuning in and staying for the entirety of the training session. Before we wind up, I would like to call upon Ashwini ma'am to speak a few words.
Okay, thank you, Rula. Lastly, I would like to congratulate all the coordinators and the core committee members for this effort. With what objective we have planned this particular thing, I believe that it would have reached to at least the people who have joined us today. And we hope large number of participation from them based on the inputs what has been conveyed to them through this particular training session. With that last note, I would like to tell them that we are anticipating for the large number of participation, and it will give you an effective experience to be a budding lawyer, to take up your legal profession. And I wish you good luck. And if you have any queries, we have provided with the links and the contacts, and it is informed to approach them. And let me congratulate once again all the coordinators and committee members, and I would like to convey thanks to Madhu sir as well. Thank you, one and all.
Thank you, madam. Welcome.
Thank you, sir.
Thank you, ma'am. Thank you, ma'am.
Thank you.
If there is any doubts, any small doubts which you need it cleared, then you can just ask the questions. You can just open your videos and unmute yourselves and ask questions. Anybody, any questions? It's not like you have to ask the question here only, then only it will be clear. Whatever doubts you have, if you can contact us personally, or else you can put it in the group. We'll clear the doubts. And also there is clarification. And one more thing is, there is only entry for 40 teams in Moot Court. So make sure you register yourself as soon as possible. If it exceeds 40, then we'll be unable to accommodate. So make sure you register yourself as soon as possible. So is there any doubts which needs to be cleared?
At least some inputs from the participants regarding this training session. It will be encouraging for us to take up a few more training sessions before we go for intra-class competitions, if you provide your inputs. I think nothing is there. Okay. Arun.
Ma'am.
Yes.
Thank you, ma'am. It was helpful, ma'am.
It was helpful. Okay, fine. Are you taking part in the inter-class competition? Have you registered?
Ma'am, yeah, so only I should, ma'am.
Okay.
Yes, I am planning.
Have you made up your mind from this session after getting the inputs to take part?
Ma'am, yes, ma'am. Yes, ma'am.
Okay. Okay. Thank you.
Thank you.
Ma'am?
Prerna. Yes.
Yes, ma'am. Ma'am, about the researcher's test, I had to ask whether the questions will be based on the facts or will they be based on questions of law, or just what will the questions be based on?
You'll get answer from the concerned person. Researcher test. Naveen.
Hi, good evening. So the researcher's test will mostly be based on facts of the case and the provisions that are invoked in the moot proposition. That's just about it. But it's mostly based on the facts.
Right, thank you. And also, could you please share the PPTs which you just, in the beginning, which you just shared in the group?
Okay, that will be done.
Thank you.
Any more questions? So we hope that everything is cleared. With that expectation, will wind up now, Naveen?
Yes, ma'am.
Okay, thank you all for your participation. Thank you.
Thank you, everyone.
Thank you,
ma'am.